Did you know that the facts that the charging party gives to EEOC should be vetted in the same way the pro se litigant vet his or her facts for the lawsuit? It could literally make a difference between whether EEOC would take on your case or not. You want to hear this, so let's get started.
The evidence must be material or relevant to the claim and reliable or trustworthy. And this is EEOC's standard. And doesn't it sound familiar? A couple of weeks ago, I uploaded this video before you file your complaint. Vet the raw facts. And you want to do the same thing for your EEOC charge. If you want a shot at EEOC representing you, you must demonstrate that your charge has plausibility. Vet for the EEOC charge like you would for a litigation complaint. I cannot stress that enough. And we're going to look at three areas: the detailed allegations, identifying the parties, and relevant documentary evidence. So let's look at the detailed allegations. The timeline of events, including exact dates, locations, description of discriminatory actions. Now remember, here you are telling your story. The description must be in chronological order. It needs to be clear. Stick to the raw, true facts because you will be tempted to embellish. Stick to the raw, true facts because opposing counsel will attempt to confuse you, especially during depositions. And one thing about telling the true, raw facts, you remember what you said, and you will always remember those facts, and you will always be consistent. And that goes a long way in litigation. And the same rule applies if your action is for retaliation. Two, identifying parties. The names. In some instances, you may not know the name of the party or parties, and that's okay. In the interim, you could list them as John Doe because you will get an opportunity to demonstrate their identity. Their job title or titles, because based on their job title alone, that individual could be subject to a liability that they otherwise would not have been subjected to. And EEOC needs to know this so that they can match the standard of this position to your descriptions of the discriminatory action that this particular employer or employee took against you. And remember, filing a Title VII employment discrimination case, the plaintiff can only sue the company. However, the plaintiff can make some assertions of discrimination against employees of the company that connect, or the EEOC could connect employees' conduct to the company thereby possibly making the company liable for the discriminatory charges that the employee has brought against the company. Contact information of the parties. The alleged discriminator or discriminators. And this is critical that you make it clear that the person that you are referring to, what their participation in the matter was. Make sure if it's the alleged discriminator, make it very, very clear because you also want to identify witnesses. And witnesses are not necessarily an alleged discriminator. You see my point? Human resource staff that was involved. Number 3, relevant documentary evidence. The company policies. This is critical. Did the company comply with its policies in the action or actions that it took against the complainant? Because the company usually uses policy to show that their actions were legitimate and non discriminatory. Email messages. Now, this is a really critical one, and I always advise the pro se to get some assistance from an attorney on this one, okay? But relevant email messages are good because they show the timeline, the exact dates and times, disciplinary action, or the retaliatory responses. They are also good for establishing that the company was put on notice of its employees' discriminatory action or retaliatory action. But again, I want to stress to you to get some help on these emails before you disclose them, because I can assure you that once you disclose these emails, the defendant will now at least argue that they're entitled to all your other emails. But don't buy that because the rule is that the emails must be relevant. Okay? And pay stubs, particularly if the charging party is claiming discrimination and as a result resulted in lost wages due to the discrimination. So EEOC would want to verify the wages to calculate potential back pay or front pay to address the claim of disparate treatment. And there are other reasons why providing pay stubs would be helpful to EEOC. The performance review establishes pretext. In other words, the articulated reason, legitimate, non discriminatory reason the employer gave for having taken the adverse action against the charging party was really not genuine, but it was pretext for the charging party having complained about discrimination. And especially if the adverse action took place almost immediately after the charging party complained, that's a good argument for the causal connection requirement in a retaliation claim. Text messages. Well, really, you can use the text messages, or EEOC uses the text messages in the same way they use emails. But let me just add some things that I don't believe I mentioned with the emails. One, the text messages assess tone and context, especially in a case where the charging party has alleged a hostile work environment. Text messages also establish the causal connection element of retaliation. So remember, EEOC's job is to investigate whether reasonable cause exists to believe discrimination occurred. And let me say this: receiving a right to sue letter from EEOC that states no cause found is not necessarily the end of the case. And that is evident by the mere fact that in the same letter, EEOC will tell the individual, or the charging party, that they can sue privately in federal court. But here's what I would recommend if it happens to you. If you receive a right to sue letter from EEOC stating no cause, go back and revisit your facts and re-vet your facts. But this time include the information, the investigative information that you received from EEOC and any other information you may have received. Put it all together, vet it like you would if you were going to file a lawsuit, and determine whether your case has plausibility or merit, at least to the extent if defendant filed a motion to dismiss, you could overcome it or survive it. And when, after you have revetted your facts, you believe you have plausibility or there's merit in your case, you can move forward with it. But just be ready to demonstrate to the court that you believe, based on the facts and your vetting of the facts, that your case had merit or has merit. I trust this was helpful to you and encouraged you. And until next time, I'm Advocate Lucinda, your empowerment lawyer. Take care.